Mic check. Okay. All right. Hello, everyone. Good evening and welcome to NLTI. My name is Mansi. I am going to be your guide and your mentor and your friend for this live session that it is. Right. So, we are here because we are going to discuss your PYQs and so that you can formulate a strategy for your preparation for the legal reasoning section of the CLAT exam. Right now, if you're here, I am assuming that you are, of course, preparing for the CLAT exam that's going to happen in the month of December this year, right? Which means you clearly have less than 1 year now with you to prepare for the entire exam. So if you're just starting out or if you are in the middle of your preparation, whatever is the stage, what is really important that you have a good strategy for your entire preparation, right? And you can only ensure that there is good preparation if you have understood the PYQs properly. Now, I am someone who comes from a legal background, right? I am a law graduate and postgraduate from NLU Shimla. I'm currently pursuing a PhD in law, right? And I have mentored and taught a lot of law aspirants. So I'm someone who can be helpful to you in understanding what strategy is going to be appropriate for the legal reasoning section, right? So with my fair share of experience in the field and by what all I have understood about CLAT so far, I will be sharing the strategy, the roadmap that you should be adopting and you should be following for cracking CLAT 2027, especially the legal reasoning section. Before that, let's understand a little bit about the exam. If you know CLAT, you know that CLAT has 120 questions and you have to solve those questions in 120 minutes, right? And there are 5 sections broadly: English, critical reasoning, legal reasoning, GK current affairs, and quantitative techniques, right? And there is different weightage given to all these sections. Legal reasoning in itself has a weightage of around 25 to 30 30 questions, which means around 25 to 30 marks, 24 to 30, right? So this is something which we have observed in the previous question papers also. And to understand how you should be preparing for this section, let's first of all go through the question paper of last year of the exam that has recently happened in the month of December and see what sort of questions were asked and how can you actually prepare your strategy, how can you prepare for the exam based on the type of questions that were there, right? So without any further delay, let's get started. If you have any questions, please use the chat box. I will be taking up all your questions, answering all your questions as and when I can. All right, let's just quickly get started. So so this is your CLAT question paper of CLAT 2026, right? And let's just quickly go through it. Like I've already mentioned, there are 5 sections in this exam, right? English, current affairs and GK, legal reasoning, logical reasoning, and quantitative aptitude, right? So legal reasoning has around 24 to 30 questions, like I've mentioned, right? This one here has 30 questions. So how the legal reasoning section was there in this exam? There were 5 passages and each passage had 6 questions based on the same. So now if you know CLAT, you'll also know that CLAT is totally comprehension based. So there's a passage that will be given to you, and based on that passage, there are going to be questions that will be asked, MCQs, and that you have to answer. Now, without any further delay, let's just quickly start and let's just quickly scroll through the legal reasoning section and see what sort of questions were there. Might take us some time. Okay, this is still section 2. Right, a lot of scrolling. Great. All right, here we are in the third section of your legal reasoning of your CLAT exam, which is your legal reasoning section. So just to ensure that you can read it properly, I can also read it properly. I'll just adjust the screen and I hope it's all readable to you. Now, see, this is a passage which is about few policies that have been introduced by the government of India, especially the policy of one nation, one election, right? And if we just quickly look at this, this passage has 351 words. This is something which already has been mentioned, and it has been taken from an article written by Milan Vaishnav, right? And this is something, one nation, one election is something which has been discussed under this article. Now, under this passage, so what are we going to do? We'll quickly, first of all, read the passage carefully, and then we'll see what sort of questions have been asked, right? So, the passage reads that one of the central motives of the past decade of governance under Indian Prime Minister has been the embrace of policy measures that seek to apply uniform solutions to desperate policy dilemmas facing the country. These measures, often termed one nation policies, are motivated by a desire to replace the existing patchwork of the state specific policies, regulations, and regimes with measures that are identical across the length and breadth of India. There are numerous examples of such one nation policies being propagated and, in several cases, implemented in the 11 years since the government came to power. For instance, in 2016, Parliament passed a series of constitutional amendments to introduce a new GST, Goods and Service Tax, which introduced a unified value added tax in place of state specific levy. This reform, known informally as One Nation, One Tax, has been debated and discussed for nearly 2 decades and was widely touted as an important precursor to forging a common market across India's 28 states. In a similar vein, the government rolled out a new initiative to allow Indian citizens to take advantage of subsidized food ration irrespective of their state of residence. This scheme, commonly termed One Nation, One Ration Card, was intended to increase access to welfare benefits, especially for the millions of internal migrants in India without a fixed place of residence. Earlier this year, the government announced the launch of a new online portal that will provide students, faculty, and researchers across the countries public higher education institution with open access to international scholarly journals and articles under a scheme it has dubbed One Nation, One Subscription. And lastly, most notably, the government recently signaled its intention to pursue a monumental one nation policy that has been long discussed but only recently outlined in detail. This one nation policy, this measure, known as the One Nation, One Election, would do away with India's current system of staggered elections for state and national assemblies, replacing it with a system with a framework of simultaneous elections. The proposal, which has featured in many of the PM speeches in the past, was advanced by a high level committee established by the government in 2023. All right, 351 words took me around 3 to 4 minutes to read it, right? So, one thing is that, of course, you will need some time to read it, right? It will take you some time to read. So, reading is something which is very important because around every passage is of the same length, right? So, 3 to 4 minutes for reading. Now, let's just quickly go to the questions that are there. First question is, what is the underlying idea behind the one nation policies of the government, right? So there are four options that you have: to strengthen federalism, to apply uniform solutions, to decentralize governance, or to promote diversity. Now, answer to this is in the passage itself, right? So, right. Now, here it is. One of the central motives to apply uniform solutions to desperate policy dilemmas being faced by the country. Now, if we go here, right, directly here is the answer: to apply uniform solutions across India. Easy, simple, right? Very first line of the passage only is answering the first question. So, of course, not a lot of external information is required in that case. Secondly, the second question that you have is, which of the following constitution amendment bill deals with empowerment of Election Commission of India to implement simultaneous state and election commissions? Now, this is a question which is not related, I mean, of course, related to the passage, but the answer to this question is not directly there in the passage, right? So this is asking you about a constitutional amendment that has happened, which has introduced the concept of one nation, one election, basically. So you do not know this because it's not there in the passage, but you must know this. Why? Because, see, first of all, the answer to this is 129th amendment, right? And it was something which was introduced in December 2024, right? And I've said it a lot of times, I'll say it again, that for any exam that is supposed to happen in December 2025, you know, all the legal developments that has happened in the past 1 year, automatically becomes important. Now, CLAT usually happens on first Sunday of December. So anything that is happening after that will automatically become relevant for the next CLAT that is going to happen. So now CLAT 2024, 2025, it happened, it probably happened, might have happened on 6th or 7th of December. Now this amendment act, it was introduced on 13th or 14th of December of 2024. So automatically it becomes important because, one, you are discussing current affairs, you're discussing about some amendments that is happening to the constitution, you're discussing some legal affairs. All of it automatically becomes really relevant and important for your exam that is going to happen next year. So this is something which you must have prepared if you are appearing for CLAT, and this, otherwise you would have prepared in your GK and current affairs section, not in the legal reasoning section, right? But even if you've prepared it for your GK and CA section, you could have answered it really well, right? So yes, not directly, the answer is not there in the passage, but the something which is expected out of you if you're preparing for CLAT. Now, the next question is, which committee or report has discussed the feasibility of simultaneous elections in India? Now, again, if you will read about the constitutional amendment bill, which basically has introduced this law, right? Automatically, you will also read about the committee or the report which has introduced this. Now, again, the answer to this basically is the Law Commission of India report 2018. So to understand the entire concept a little properly, right? So Law Commission of India basically gave a report. In Law Commission of India report, basically some reforms or suggestions are given to policy makers and the parliament for what sort of laws are required or what sort of changes are required in the law. So in 2018, Law Commission of India, it made a report, and in that report they suggested that there is a need for one nation, one election policy. And after that, what happened? So to act upon the same, the government of India, they made a high level committee, which was also mentioned right there in your passage. Here, the proposal which featured in many of the PM's speeches in the past was advanced by high level committee established by the government in 2023. So what has happened here? That in 2018, the report was given, right? And to act upon the same, a high level committee was made in 2023. And what all the committee submitted as a report, right? Based on the same, in 2024, on December 2024, this constitution amendment bill was introduced in the parliament. So this is how it has happened. So whenever you will try to understand or know about the constitution amendment bill, the background of the same should also be prepared. So take away this from this thing, right? That if you're preparing any current affair or GK, especially any recent legal development that has happened, please understand the background of that development as well, from where it has originated, what all has been done so far, what that amendment is actually trying to do, right? The purpose behind the same. That also has to be tested. Now, let's say, okay, wow, now, okay, let's say one thing is that you probably do not know answer to this question. So would you, I mean, it's still not very difficult to guess, because if you look at if the passage here mentions that the high level committee was made in 2023, which sort of means that all the development that has happened around this topic has happened somewhere near or closer to 2023 only. So if we look at the years that have been mentioned here, 2023, 28, 2018, 1988, 2010. So 2018 automatically is a little closer to 2023 as compared to the other ones. So clearly in that case, you can still take a guess, but do not take wild guesses if you're unsure, right? But the answer to this is this one. This you could have only answered if you have understood the constitutional amendment bill, 129 constitutional amendment bill. Okay. Next question that we have is that a high level committee was constituted by the government to examine the policy of one nation, one election. The committee was led by, then there are four options. So I just mentioned that a committee was formulated after the Law Commission report of 2018, and the report was, and it was made in 2023. And they gave a report based on which the amendment bill was introduced. So now the question is that for of that high level committee, who basically was leading that committee? So this again, GK current affair based question. You can only know it if you have understood the amendment bill properly, if you have read your GK and current affairs properly. The answer to this is Ramnath Kovind, Sri Ramnath Kovind, right? And he was leading the high level committee. So yeah, that is how it is. The fourth question is, as per the GST reforms introduced in September 2025, what is the structure of new GST rates? So again, a GK current affair based question, some legal development, some amendments in the law that has happened in September 2025 is being tested in December 2025. So what is the takeaway from this? That anything, I mean, it doesn't mean, I usually get it, I've heard it from a lot of mentors that you should be preparing your current affairs till August or July of the same year. All right. Okay, just give me 1 second. Let me just quickly get a few things fixed. Visual. Hmm. Okay. Hi everyone. Good evening. Sorry for the glitch. All right. The camera sort of stopped working, but now we are back. I hope I'm properly audible and visible again. Great. So let's just quickly continue with wherever we were. So I was telling you about the new GST reforms. Now I was mentioned this one thing, that something that has happened in September 2025 is being tested in December 2025, which is something I've not heard from a lot of mentors or law faculties or law CLAT faculties. Usually, what we've heard is that you should be preparing your current affairs till July or August. But one really important thing to note here is that something that has happened in September also can be tested in your December exam. So this means that all sort of current affairs, you should be properly updated. Now, again, coming back to the question, it says that as per the new GST reforms, what is going to be the new structure of the GST rates, right? So now, again, this is not something which is there in the passage. This is again your GK and current affairs being tested. Now you will be like, ma'am, why GK is being tested in legal reasoning? Because this is related to law, right? These are legal developments that has happened, and that's something which is directly being tested. So again, very important takeaway, any recent legal developments that have happened, please be updated. It can be directly tested in the exam, right? So now you, if you only you know it, if only you've heard about the same, only then you will be able to answer it, right? So the answer to this is 5, 12, and 40%. Sorry, my bad. 5, 18 and 40%, not 12, right? And this you could have only answered if you have absolutely made yourself aware with your current affairs and GK. Next question that we have is the object of One Nation, One Ration Card scheme. Now, thankfully, we finally have a question, the answer to which you can find in the passage, right? So the question is, what is the object of One Nation, One Ration Card? Now, let's just quickly go back to the passage. And let's just see where the answer can be. Okay, so it says One Nation, One Ration Card intended to increase access to welfare benefits, especially for the millions of internal migrants in India without a fixed place of residence. Okay, this is just the only time where this One Nation, One Ration Card has been mentioned. This is just one line that is there. Now let's just go back to the passage and see what options do we have. The rural population, the farmer, the migrant laborers, the ration shopkeepers. So the answer to this, as per the passage, is the migrant laborers. Simple, right? So there were 6 questions that were there, out of which 4 were related to GK and current affairs. 2 questions were from the passage directly, right? Now, moving ahead with the next passage that is there, we'll just quickly read it. Okay, it says that I may here trace the history of the shaping of the preamble, because this would show that the preamble was in conformity with the constitution as it was finally accepted. Not only was the constitution framed in the light of the preamble, but the preamble was ultimately settled in the light of the constitution. In the earliest draft of the preamble, was something formal and read, "We, the people of India, seeking to promote the common good, do hereby, through our chosen representatives, enact, adopt, and give to ourselves this Constitution." After this plan of June 3rd, 1947, which led to the decision of partition of the country and to set up 2 independent dominions of India and Pakistan, on June 8, 1947, a joint subcommittee of the Union Constitution and Provincial Constitution Committees took note that the objective resolution would require amendment in view of the latest announcement of the British government. The announcement of June 3 and June 3rd had made it clear that full independence in the form of dominion status would be conferred to India from August 15, 1947. After examining the implications of partition, subcommittee thought that the question of making changes in the objective resolution could appropriately be considered only when effect had actually been given to the June 3 plan. Later, on July 12, 1947, the special subcommittee again postponed consideration of the matter. The Union Constitution Committee provisionally accepted the preamble drafted by B.N. Rao and reproduced it in its report of July 4, 1947, without any change, with the tacit recognition at the stage that the preamble would be finally based on the objective resolution. In a statement circulated to the members of the assembly on July 18, Pandit Jawaharlal Nehru, inter alia, observed that the preamble was covered more or less by the objective resolution, which it was intended to incorporate in the final constitution, subject to some modifications on account of the political changes resulting from partition. Right? So there are 327 words that are there, an extract taken from B. Shiva Rao's framing of Indian constitution. So basically, whenever the constitution was made, right? So any discussions that has happened around drafting and framing of the constitution, that is something which has been discussed under this passage. And now that we have read it, we have seen that it is a lot of discussion has happened around the preamble of the constitution in this passage. So you can expect questions around the preamble, right? That basically is the intent of the consortium to test how well do you understand the preamble. Now let's just quickly go to the passage and see. According to the passage, the relationship between constitution and the preamble can be best described as: number one, the preamble was drafted in isolation. The constitution, number two, the constitution and the preamble were framed independent of each other. C, both the constitution and preamble were shaped in the light of each other. And D, the preamble had no relevance to the constitution. Okay, now if we just quickly go back to the passage, you'll see here it says not only was the constitution framed in the light of the preamble, but the preamble ultimately settled in the light of the constitution. Now, if we go back to the question here, we have two. The third option, it says both constitution and preamble were shaped in the light of each other. So the answer to this question is directly there in the first 2-3 lines only of the passage, right? So of course, not very complicated. If you have read the passage carefully, you can just answer it in no time, absolutely no time. What is important? That you read the passage carefully. Now, moving ahead, the next question is, what did the earliest draft of the preamble emphasize? Liberty, equality, fraternity, or sovereign, socialist, secular, democratic republic, formal enactment by the people through representatives, or unity and integrity of the nation. Now, again, let's just quickly go back to the passage. Okay, I remember reading it somewhere. The early draft. Right. Yes. In the earliest draft, preamble was something formal and read so and so and so. Right. So now if we go back to the passage, here is the option which says formal enactment by the people through representatives. Same way. Formal, and it read that we choose, people of India choose its own representatives and give ourselves this constitution. Right? So again, if you've read the passage carefully, it's not very difficult to spot the answer. It's right there in the passage only. So the first answer, the question to the first answer was in probably the second line, and the question to the second question is in the third line. So two questions can be done very easily even if you do not know about the same. All right. So third is, which of the following is not enshrined in the preamble of the Constitution of India? Right. So the options that we have is equality status of opportunity, right? The second that we have is um, liberty of thought, expression, belief, faith, and worship. Third is justice, moral, ethical, and legal. And fourth is fraternity, assuring the dignity of the individual. Now, the answer to this is not in the passage. This is something which you should know, which you must know if you have prepared Indian polity, if you have read Constitution of Law. Even if you have not read, let's say, Constitution of Law, even if let's say you're just a CBSE student, right? In your all your textbooks, all your NCRT textbooks that are there, at the beginning, at the very first page of all the books, there is going to be a preamble of the constitution that is attached. So this is the answer to this is in your own NCRT textbooks. If you are a CBSE student, you'll know about the same, right? Okay, now The answer to this is not in the passage. So if we look at it carefully, you'll see the preamble talks about equality, liberty, justice, and fraternity. It does, right? But when it comes to justice, it does not talk about moral, ethical, and legal justice. For this, you have to also, you can of course confirm this from the preamble of India also. It talks about social, economic, and political justice, and not moral, ethical, and legal justice, right? So, of course, it talks about justice, but not this justice, not moral, ethical, but social, political, and economical justice, right? So, this is not, so the C answer is basically the correct answer, that this is not enshrined in the preamble. Okay. Now, after this, the next question that we have is what is the correct order of um, which has been rightly arranged according to the preamble, right? So you might have seen this in your in your preamble as well, that in the opening only, right, there has been a mention of your few terms, right, like sovereign, democratic, socialist, republic, so and so. We basically give features of the Indian constitution right there. So what is the correct order of the same? Now again, the answer to this question is not there in the passage, right? This is again something which you will know if you have read the constitution, right? So now the answer to this is sovereign, socialist, secular. Now democratic, republic, it remains the same, right? I usually, when I was in law school, I used to remember it by triple SDR. So it's always easier because you will know that DR is going to be the same. But what really matters, and if you will see, triple S is almost everywhere, right? Apart from this, not for this one, but otherwise triple S is always there. So the correct order is sovereign, socialist, secular. This one, right? So democratic republic remains the same. This is there, what is there in the constitution directly. So if you know what the constitution, what the preamble is saying, then you can answer it properly. Otherwise, the passage is directly not helping you with the answer to this question. Okay. Then moving ahead with the next question, preamble of the constitution is based on what? Now, thankfully, again, the answer to this passage question you will find here. It says that the preamble was covered more or less by objective resolution. Now, again, if we go back to the passage, the first option itself talks about the objective resolution. Simple. Okay. So, two questions so far out of four, right, have been from the passage. The other two have been, sorry, 1 and 2. Yeah, 3 questions out of 5 have been from the passage directly. 2 questions are about your knowledge about what preamble has said, right? What all has been written in the preamble. Okay, last question from this passage is, what is the role of Sir B.N. Rao in the making of Indian Constitution? Now, the answer to this is not in the passage, but you'll see that the Constitution Committee accepted preamble as drafted by B.N. Rao and reproduced it in its report without any change. So it might appear that he is one of the members of the Constituent Assembly. The options that we see here is, right, one, if he was the chairman; second, if he was the constitutional advisor; third, if he was the president; fourth, if he was the member of the Union Powers Committee. So, see, chairman and president, we might have heard it a lot of times about Dr. Rajendra Prasad, Dr. B.R. Ambedkar, right? K.M. Munshi. A lot of people have been part of the drafting committee, right, of the Constituent Assembly. And you might have heard a lot of names as well. However, B.N. Rao was not part of the Constituent Assembly at all. B.N. Rao was advisor. He was a constitutional advisor to the Constituent Assembly and not a member. So again, this is something which you can only know if you have read about the Constituent Assembly, which again is very important. Why? Because see, CLAT would not want to check how well do you understand constitutional law. You're just appearing, you are a law aspirant, so you might not have a lot of answers for the same. But the background behind constitutional law, which we otherwise read in history in our school, that is something which can be tested, right? So this is not a question from constitutional law. Constitutional law will never talk about Constituent Assembly or the members of Constituent Assembly, right? But this is somewhere your 8th or ninth class ka history, or it's also part of your civic subjects, right? So this is something which is expected for you to know. Otherwise, if you do not know answer to these questions, 3 questions out of 6 are directly from the passage. 2 questions are about the preamble. 1 question is about the Constituent Assembly, right? Still, let's say you have absolutely no idea about what the preamble has said. You have absolutely no idea about what the Constituent Assembly has said or has done, who were the members, what is the role of which person. Let's say you do not know about anything. That's absolutely fine. Still, you can answer 3 questions if you have read the passage carefully. And this was also something which we saw in the first passage, that around 2 to 3 questions were directly from the passage. So what we can understand from this is that around 50 questions, sorry, 50% questions on in each passage are directly related to the passage that is there. However, another 20, sorry, another 2 or 3 questions, or remaining 50% questions can be GK or current affair based, or some static information that you should be knowing about. Okay, so this is something which you can understand from these 2 passages. Now, okay, let us understand the third passage then. Okay, we'll just quickly read through this one. It says that good governance is only in the hands of good men. No doubt what is good or bad is not for the court to decide, but the court can always indicate the constitutional ethos of goodness, good governance, and purity in administration. Remind the constitutional functionaries to preserve, protect, and promote the same. That ethos are the unwritten words in our constitution. However, as the constitution makers stated, there is a presumption that the Prime Minister, Chief Minister would be well advised and guided by such unwritten yet constitutional principles well. According to Dr. B.R. Ambedkar, such things were only to be left to the good sense of Prime Minister and for that matter the Chief Minister of State, since it was expected that the two great constitutional functionaries would not dare to do any infamous thing by inducting an otherwise unfit person to the Council of Ministers. It appears over a period of time, at least in some cases, it was only a story of great expectations. Some of the instances pointed out in the writ petition indicate that Dr. B.R. Ambedkar and other great visionaries in the Constituent Assembly have been bailed out. Qualification has been wrongly understood as the mere absence of prescribed disqualification. Hence, it has become the bounden duty of the court to remind the Prime Minister and the Chief Minister of the state of their duty to act in accordance with the constitutional aspirations. No doubt it is for the court to issue any direction to the Prime Minister or the Chief Minister, as the case may be, as to the manner in which they should exercise their power while selecting the colleagues. That is the constitutional prerogative of those functionaries who are called upon to preserve, protect, and defend the Constitution. But it is the prophetic duty of this court to remind the key duty holders about their role in working the constitution. Hence, I am of the firm view that the Prime Minister and the Chief Minister of the state, who themselves have taken oath to bear the true faith and allegiance to the Constitution of India and to discharge their duties faithfully, will be well advised to consider avoiding any person in the Council of Ministers against whom charges have been framed by a criminal court in respect of offences involving moral turpitude and also offenses specifically referred to in Chapter 3 of the Representation of the People Act. Simple. This is something which has been taken from a Supreme Court judgment, right? Something which the Supreme Court directly has said in this judgment, Manoj Narula versus Union of India. Okay, simple judgment, right? Simple, very simple and easy to read passage. The court basically is saying that the chief minister and the prime minister, they should be really careful regarding which person has to be added into the council of ministers, right? It is basically the crux of the entire um, passage. They do not want criminals to be part of the council of ministers. That's as simple as that. Now, if we have understood the intention of the passage, by that, let's just quickly understand what sort of questions are there. First is, according to the passage, the court cannot decide what is good or bad governance, but it can do what? It can disqualify ministers, it can indicate constitutional ethos, it can frame rules, or it can amend the constitution. Now, the answer to this is directly there in the first line or the second line itself to indicate the constitutional ethos on goodness, good governance, so and so and so. Simple, right? If you've read the passage, you can answer it in absolutely no time. Okay, moving ahead. Dr. B.R. Ambedkar believed that the working of constitution ultimately depends on the rigidity of the constitution, good sense and integrity of those people who are administering, the presence of a strong opposition, judicial intervention. Now, again, the answer to this is in the passage. We've read the passage just now, and we can see that here is the mention of Dr. Ambedkar. Let's just quickly read this one sentence carefully. It says that some of the instances pointed out in the writ petition indicate that Dr. B.R. Ambedkar and other great visionaries in the Constituent Assembly have been bailed out. Qualifications have been wrongly understood as the mere absence of the prescribed disqualification. Right? So, and here also is one other mention of Dr. B.R. Ambedkar. He has said that these things should be left to good sense of the prime minister, and for that matter chief minister of the state, since it was expected that these two great constitutional functionaries would not dare to do any infamous thing by inducting an otherwise unfit person. Now, so if we go back to the MCQs now, the question, right? So the answer to this is this one. It is directly there in the passage. The good sense and integrity of those who are going to administer the constitution, right? Directly there in the passage, even if you do not know anything about the role of council of minister, prime minister, chief minister, constituent assembly, constitution otherwise, you can still answer it very easily. Next question, that the court, while respecting the prerogative of PM and CM to select, emphasize that they should avoid appointing person with criminal charges. They must appoint ministers strictly from the ruling party. They should consult the Supreme Court before finalizing. They're bound to appoint only members of Lok Sabha or Legislative Assembly. Now again, the answer to this we found here, right? Avoiding any person in the Council of Minister, right, who is involved in any moral turpitude or any other offense, who has been criminally charged or has been involved in any moral turpitude. So the answer to this is the first question. Simple, right there in the passage. Not a lot of, a lot of information about the topic is not required. What is required that you just read the passage carefully. That's it. Okay. Now, what does the court assume as described in the passage regarding governance and appointment to the Council of Ministers? That it judicial review of all ministerial appointments, prophetic duty to remind key functionaries of their constitutional role, power to veto ministerial selections made by the Prime Minister, directing Parliament to amend the law on disqualification. So, what is going to be the answer to this? I remember, yeah. Okay, All right, let's just quickly find the answer in the passage. What basically is going to be the duty as per the passage? So, see what we have understood so far by reading the passage also. I'm very sure the answer to this is directly there because I've read it. I'm also finding it. But one thing that we also have to understand that the intention so far of the Supreme Court in the passage has been very simple, that whosoever has been given any role to perform in the constitution should be doing it properly, right? So that is something which the intention uh, of the Supreme Court has been. So it has not talked about judicial review. It has not talked about power of veto. It has not talked about amendment to the law of disqualification. But yes, it has talked about the role of people who have been given a constitutional role, right? So this is something which you anyway can understand from the passage also. But yeah, if we see here this sentence, it says that the constitutional prerogative of these functionaries is to preserve, protect, and defend the constitution. It is the prophetic duty of this court to remind these key holders their role in working of the constitution, something which again has been directly mentioned in the passage also, but also something which you can deduce from the passage also. If you've read the passage carefully, you do not have to go back and find the answer. You can just take the guess also. It's that simple. But let's say you're still not sure, and just to confirm also, it is something which is there in the passage already. So if even if you just go back, right, and try reading the last paragraph for one, so just for once, you will be able to answer this question very easily in a very simple manner, very effective manner, right? So it's not going to be too difficult. Who are the constitutional functionaries that have been referred in the passage? So I think we've read the passage and we know that only Prime Minister and Chief Ministers have been discussed, and their role and their responsibilities have been discussed. So the answer to this is going to be Prime Minister and Chief Minister, right? Next, we have who, according to the above passage, should not be appointed as a minister. Again, this is also something which we have read already. Also, something which is directly related to the question which we have already answered. The answer to this is against whom charges involving moral turpitude have been framed in a court of law. Very similar to question number 67, right? Also, directly there in the passage. So, what we can take away from this um, passage is that all the answers to the questions were there in the passage only. If you read it properly, right? A little lengthier passage, right? But all the answers were there. A little boring to read, also, honestly. But still, all the answers were there. So, if you just, give a careful 3 to 4 minute reading to this passage, all the answers you can very, very easily answer. It's not going to be too difficult. All right. So, without this one's also quite simple. This one's more application based, but what I'll do here is I'll just take you to another passage, right? There were 6 passages. I'll take you to another passage which is around the same-sex marriage. Now, if we just quickly go at the end of this, right? This has been taken from the Hindu, right? An article has been taken from the Hindu, which was published in the Hindu in October 2023. And just if we just quickly read the passage, it's a short passage, it's not too long. It says same-sex marriage has no legal recognition in India, as per the recent Supreme Court's judgment, where it was decided that this is an issue for Parliament to address. While Hindu marriages between transgender person and cisgender men are permissible, and the court acknowledged systemic discrimination and the right to choose a partner, it held that there is no fundamental right to marry. The government has been urged to form a panel to consider granting more legal rights to same sex couples, but the legal status of marriage remains unchanged for now. The 5 judge bench of the Supreme Court of India in Suprio versus Union of India, in a majority verdict, ruled that there is no fundamental right to marry under the Indian Constitution, making it beyond the court's scope to legislate on same sex marriage. The court stated that the power to legislate on same sex marriage rests with the parliament and state legislatures. The judgment affirmed constitutional rights for LGBTQ plus citizens and the right to choose a partner. The government agreed to set up a panel to explore legal rights and benefits for same sex couples, though these benefits are not the same as those conferred by marriage. Same sex couples cannot legally marry and do not receive the same legal rights, such as automatic inheritance, pension, or adoption rights that legally married couples do. Despite the ruling, LGBTQ plus couples continue to face legal discrimination and have no social recognition of marriage. The court affirmed the right to same sex couples to cohabit privately. While the Supreme Court's verdicts brought limited benefits and acknowledgement, it has not legalized same sex marriage in India, deferring the ultimate decision to the parliament. All right, simple 270 to 80 words ka passage. Now let's just quickly look at the questions that are there. It says that in October 2023, two individuals in India, Ramesh and Sameer, who identify as a same sex couple, sought to legally solemnize their marriage. Based on the Supreme Court's ruling, what is the current legal standing? So it's an application based question. So another takeaway, important takeaway from this is that not only you have to know about the recent legal developments, not only you have to deduce answer from the passage or find answers in the passage, but now the legal principles that have been discussed in the passage also has to be applied to the questions that are there. So broadly what we can see here is that there are three type of questions that have been asked so far, right? So, I mean, I'll not take a lot of time of yours. I'll just quickly answer a few questions here, okay? Um, so, the option to this is their marriage is legally recognized nationwide. Second is their marriage is not legally recognized, as Supreme Court ruled that this issue is for Parliament to address. Number three, their marriage is recognized only if both of them identify as transgender, or their marriage is temporarily recognized until Parliament decides otherwise. So clearly the answer is B, right? Why? Because the entire passage has talked about how Supreme Court has not legalized it. So what should be the takeaway from these sort of questions is, of course, you first of all should read a lot about what all is happening around you. Why? Because it's going to help you in understanding your current affairs which is especially legal in nature and not just restricted to, I mean, not just legal affairs which is about legal happenings of India, but if any, uh, some geopolitical development, anything that is happening around international law, also any great developments or any significant changes if that they have happened, automatically it becomes really important for your exam. Now, one more thing: do not restrict your GK and current affairs till till the month of July or August. Please keep on preparing for the same at least till let's say 10 or 15th November, right? There is a lot of possibility that things that have recently happened can be directly tested in your CLAT exam also, right? So that is also which is another takeaway. Third, that we have understood and that we have observed is you have to read carefully and you have to read quickly so that you can answer the question, so that you can identify and locate the answers directly in the passage first of all, and you can answer them quickly. Because if you read the passage carefully, let's say you spend 3 to 4 good minutes in just reading the passage, it'll be very easier for you to solve the questions, because it will then not take you a lot of time, because you know that the answer is there in the passage only, right? So overall, the entire passage can be done in less than 5 to 6 minutes, in which you give 3 to 4 minutes to reading, and 2 minutes will overall you will take in just reading the questions and understanding the options, and you can quickly find it and you can just quickly identify the answer if you have deduced the passage reading carefully, if you have located it properly, right? So reading, speed reading is another thing that you have to pay a lot of attention to. If you'll keep on reading, eventually your reading time will also decrease. If you're starting with 4 minutes per passage, and if you'll keep reading, it will eventually decrease. You will be able to read the entire passage in 2.5 to 3 minutes, which is going to save you 1.5 minute. And trust me, it is a lot in CLAT, right? Otherwise, if you have once read the passage carefully, if you'll think about it carefully, right, if you'll think about it, you do not have to spend a lot of time in reading or deducing or brainstorming about the answer to the question, because the answer is right there in the passage. Once you've read it carefully, you can just answer it in less than 10 seconds. So it's going to be very time saving for you if you have read it carefully. Then what is also very important, that how well you apply those principles, because we also have application based questions. The questions usually in this passage, most of the passages that are here, questions that are here, right, are application based questions. See, another Ramesh Suresh question has come. The situation has been given to you. You have to apply the legal principle that has been discussed in the passage, and then you have to answer the question. Only one slightly GK based question is that new acronym that is evolved after LGBTQ plus is called the LGBTQIA plus. So what is the new acronym IA refers to? Now this is not something which has been discussed in the passage, not something which is application based, not something which is deduction based, but something you should know out of GK and current affairs, right? Otherwise, all the questions in this passage were application based questions. So, legal reasoning is going to be a blend of all. Legal reasoning is going to be a blend of current legal affairs, right? And also understanding the background of those current legal affairs, reading carefully, reading quickly, finding answers in the passage, deducing answers from the passage or deducing the conclusion or meaning of the passage, applying those principles in the questions that have been tested, right? If you will master these 5 things, automatically you will score a lot of marks in your legal reasoning section. It's not too difficult. If there are 30 marks dedicated to this one section, trust me, it's not difficult to score more than 25 marks, right? And if you score, let's say 25 to 27 marks in one section only, it is going to significantly, it will have, you will notice and you will see a drastic change and a drastic difference in your rank and your overall marks as well, right? So I hope you found it useful. I hope you're taking away something important from this. So this is something which I wanted to share with you. If you'll have any questions, any doubts, please use the chat box. I'll be very happy to answer your questions. If not, then you can let me know the same as well. Any questions, anyone? All right. If no further questions, then I'll wrap the class for all of you. Thank you so much, everyone, for joining. Have a great weekend ahead. Have a great long weekend ahead. Wishing you all a very happy Basant Panchami and wishing you all a very happy Republic Day as well. All right. Thank you so much, everyone. And bye.